Unless Peter Obi, my brother, returns to Abuja, he will not achieve anything politically. He knows, because he took a vow that he will never leave Abuja. That any day he leaves Abuga, let his family die. Everybody in his family die. He said it now. But he still left Abuga. Why did he make such a vow? He left Abuga and joined PDP. He was vice president to Atiku. Now he's going for presidency. It will be a catastrophic exercise. It will not work. I'm the one telling you now.
And the reason is because of the vow.
Do you know what vow means? Maybe you are married. Are you married?
Leave my relationship status out of the league.
No, you're asking me my own. You don't want to answer my
relationship status.
Are you asking me? I'm married. I say my wedding ring. Are you married?
It doesn't really matter.
It matters now because if you are married, you must have taken a vow, and you must maintain the vow you took.
In the year 2000, like German said, 2002, I said I will stay on, I will not leave. Sit down. I'm not that I will not leave. They will die with Africa.
Labour Party, Peter Obi failed to prove Tinubu was convicted of money laundering in U.S. tribunal. And Tinubu's U.S. drug dealing forfeiture not criminal indictment, tribunal. Labour Party, Peter Obi failed to prove Tinubu was convicted of money laundering in U.S. tribunal. The five-man panel led by Justice Haruna Tamani ruled on Wednesday that no record of criminal arrest or conviction was established against Tinubu by the petitioners, Obi and the LP. The Presidential Election Petitions Tribunal has ruled that the Labour Party and its presidential candidate, Peter Obi, failed to prove that the presidential candidate of the All Progressive Congress, APC, Bola Tinubu, was convicted of money laundering in the United States. The five-man panel led by Justice Haruna Tamani ruled on Wednesday that no record of criminal arrest or conviction was established against Tinubu by the petitioners, Obi and the LP. The petitioners also argued that Tinubu was not legally qualified to contest the election, alleging that he was previously convicted and fined the sum of $460,000 by the United States District Court, Northern District of Illinois, Eastern Division, in case No. 93C4483, for an offense involving dishonesty and drug trafficking. With regard to that, the court said there were no records of Tinubu's arrest in the U.S. Regarding the allegations, the court said Tinubu still enjoyed unimpeded access to the U.S., so it was discountenanced. The court held that the petitioners failed to show that Tinubu was charged, fined, found guilty or sentenced to jail for the alleged offense relating to drug trafficking. Tinubu's U.S. drug dealing forfeiture not criminal indictment, tribunal. The Presidential Election Petitions Tribunal has ruled that President Bola Tinubu cannot be disqualified on the basis of his forfeiture of drug money in the United States. The verdict was declared by Justice Haruna Tamani-led five-member panel of the Presidential Petition Election Tribunal on the petition on Wednesday. According to the PEPT, Tinubu was previously cleared by the Nigeria Police Force of any criminal issues in the U.S., which came through an inquiry the police had made to U.S. law enforcement. The court disclosed that Tinubu has been able to enter and exit the U.S., and that suggests he has no criminal case. In his ruling, Tamani said the judgment of the U.S. District in Northern Illinois, which ordered the forfeiture of Tinubu's $460,000 in a drugs-related case, was in civil proceedings in which Tinubu was not a party. On the issue of non-qualification due to an alleged criminal indictment, the petitioners had contended that Tinubu had forfeited $460,000 in the U.S. as an indictment in drug trafficking. According to the tribunal, the evidence, Exhibit P5, tendered by the petitioners shows that it was a civil forfeiture proceedings. Justice Samani held that the petitioners failed to provide credible evidence to show that Tinubu was arraigned, took a plea or was sentenced or fined in any criminal suit in the U.S. The order of forfeiture in Exhibit P5 on which the petitioners have relied does not qualify as a sentence or fine for an offense involving dishonesty or fraud within the confabulation of Section 137 LD of the 1999 Constitution, Samani said. According to the tribunal, civil forfeiture is not a conviction or a criminal charge.